I too am pleased, well, pleased the wrong word, to try and contribute to this piece of legislation. I'm genuinely perplexed because I don't know whether it's a right or a wrong thing, or there's good and bad in everything situation. But in early June, the government approved the drafting of the bill, which is aimed at addressing the impact of recent judgments from the Courts of Justice of the European Union, CJEU. And I've often commended and complimented and said people had to go to Europe to get justice for many issues that they couldn't get justice from this country. But this is a rather a troubling case. In a case taken by the convicted murderer Graham Dwyer, the Court of Justice of the European Union, CJEU, ruled that EU law precluded the general and indiscriminate retention of electronic traffic and location data to combat serious crime. And that kind of worries me, because serious crime is serious crime, and murder is the most serious of all. And conviction, everyone's entitled to a fair trial and innocent proven guilty, but the indiscriminate use of data then for other issues is a whole different area, and which is happening, and all kinds of information being kept on individuals and ordinary peace-abiding people and just ordinary people. The Communications Retention of Data Amendment Bill 2022 will allow the general and indiscriminate retention of communication traffic and location data only on national security grounds where approved by a designated judge. And far be it from me to criticise any judge, but it's kind of troubling. The quick freeze orders in the bill also sets up a system of preservation orders and production orders. These will facilitate the preservation of and access to specified data held by service providers for both national security and the investigation of serious crime where permitted by an authorising judge. The preservation order will act as a quick freeze, requiring service providers to retain specified data that they hold at a particular point in time for a period. A production order will allow access to specified data held by a service provider for commercial or other reasons, where such access is necessary for national security and law enforcement. So therein lies the kind of grey areas as far as I'm concerned, and I have worries about this being challenged. And again, it's rushed legislation, and any rushed legislation, in my opinion, not all of it, but it can lead to flaws, obviously. And I'd like to see, as we don't with any legislation, a kind of an impact assessment after a finite period to see how it's bedding in, see has it been used, or if it's been used, has it been, has it bedded in the first case, and has it been functional and practical, and has it been fair above all else. And the Minister of Justice has said, as yourself, Minister, that the urgency of the bill was unavoidable given the need for legal certainty for the communications companies and state agencies. Certainly I agree with that. In addition to this urgent bill, you intend to bring forward more comprehensive proposals later in the year to address wider reforms and more consolidation legal framework in this area. The Department of Justice has said that the proposed changes were without prejudice to the state's current appeal to the Supreme Court of a High Court ruling on the Act. So it's a kind of if hard to get grants. So why? I know it's urgent. It's urgent for other reasons, but why is this urgent the second last week of the term? And why are you going to bring forward more robust legislation? Now you tell us you are, and this is not a personal criticism, but it's a criticism of the system. Will we have a different piece of legislation? Will it be more robust? And will it, as I said, weed out the chaff from the oats as regards, retention of data? Because, as I said, it is been retained and been used and misused in many cases. I agree where there's crime and serious crime. We must try and get a balance that we would retain data for that area. But as I said, I often encourage people to go to Europe to get justice because they don't get it here. So in this case, they've made a ruling. The Court of Justice of the European Union, as I said, the court confirms that EU law precludes the general and indiscriminate retention of traffic and location data relating to electronic communications to combat serious crime. And we did bring in, and passed here, that we would bring in tagging, which I for years advocated for, because it cut down an enormous amount of gather time, and I don't know, has that been used at all? So we're so slow here to embrace and to engage things that they have in other jurisdictions, and you know, we say we will, and we have great aspirations, but aspirations don't normally deliver. They're great in, to believe in them and have faith in them. So I have concerns, Minister, about this. I have concerns about any rush legislation, and moreover this. So I don't know. I have a very open mind on this at this point in time. But the real criticism is that, as we made the point today at the Order of Business, challenging it, that 5 pieces of legislation have been rushed through and with a proper scrutiny and debate, and it doesn't augur well for a democratic parliament. Thank you.